President Trump believes passionately that he won the 2020 election. And you're being asked these questions in hopes you will say that he didn't. Or in hopes that you will say that he did. Regardless of what you actually think, the further hope is that it'll cause the president to twist off and pull your nomination. And that's what's going on here. I'm not saying my good friend doesn't have the right to do that. Some would say it's kind of clever, but I don't think we ought to kid ourselves about what's going on. Number two, my job, I don't, this business of confirming judges has become too much of a shirts versus skins game for my taste. If I could change it, I would, but I can't. Picking somebody for the federal bench is as serious as 4 heart attacks and a stroke. You're there for life. We better get it right. And my job is to be in as I see it, is to be an equal opportunity antagonist. Now, some would use another A word to describe me, and I realize that. But that's my job. And the two biggest things going for you, Judge, I don't know. You have read your resume, it's impressive. Or John Hoeven and Kevin Kramer. If they tell me you ought to be on the Court of Appeal, I believe them. Because they understand the role of a United States Senator. There are a couple of questions I want to ask you. Why did you? I heard your answer to Senator Durbin, but you were a sitting federal judge, and I know some other judges joined you, but you wrote a letter to Columbia saying, because of what I see happening at Columbia, I'll never hire one of your graduates. Why did you do that?
Senator, I was asked to sign the letter. It was indicated over a period of time. And the reason why is because it wasn't simply a student protest that was occurring. It was a protest that was resulting in violent conduct.
Well, I know what happened. I guess what I'm getting at is our federal judiciary has lost some of its legitimacy. I'm not laying it at your doorstep, but it has. And so many Americans now feel, because they're told, that judges are just politicians in robes. Okay? They're just mini legislatures. And that's not what our founders intended, and I don't think that's what they are. And so when a federal judge expresses a political opinion like you did and your colleagues did, how does that help our effort to help the public understand that judges aren't politicians?
Senator, I've been told a lot that federal judges have a lot of power, and you've said it, I think, in other hearings and contexts. But our power is limited. It's significantly limited to the case or controversy before us. We don't have the power of an executive. We don't even have the power to change laws like you do as a legislator.
I get that, Judge, and you're a judge. You can do what you want. I hope you won't do something like that again. I'm not saying you don't have the right, but when you adopt a political position, which I happen to believe with, frankly, to do that as a private lawyer is one thing. To do it as a sitting federal judge is quite another. And I just don't think it's a good thing. That's my personal opinion. You don't tweet anymore, do you?
I do not.
Okay. You don't go on social media at all?
I go on social media to follow other people, including...
Sure, but not to post.
Not at all. In fact, I think I know the name of your elliptical.
Yeah. Margaret and I had a date Sunday night. She won.
In the carport.
In my carport. She won.
Candid and unfiltered atmosphere took over the Senate Judiciary Committee hearing as lawmakers cut through the standard political theater to address the real undercurrents of the judicial confirmation process. The session quickly evolved from a critique of partisan trap questions into a serious, high-stakes discussion on how sitting federal judges must protect the integrity of the bench from public cynicism. The hearing opened with a refreshing dose of blunt realism, dismantling a line of questioning aimed at forcing a judicial nominee into a political minefield regarding the 2020 election. The presenter explicitly called out the strategic theater at play, noting that such inquiries are rarely about a nominee's legal qualifications and almost entirely about generating a political flashpoint. We all know exactly what is going on here, and we shouldn't kid ourselves. This line of questioning is a calculated trap. The hope is to corner the nominee into a response that will cause political friction or provoke an executive withdrawal. This confirmation process has become far too much of a partisan shirts versus skins game. Picking someone for the federal bench is as serious as 4 heart attacks and a stroke. You are there for life. Our job isn't to score cheap political points. It's to get it right. The presenter made it clear that their role is to serve as an equal opportunity antagonist to ensure absolute judicial readiness, leaning heavily on the trusted endorsements of home state senators who truly understand the constitutional weight of a federal judgeship. The core of the debate intensified when the presenter questioned the nominee, a sitting federal judge, over a public letter they and several colleagues signed. The letter informed Columbia University that, due to the nature of the protests occurring on its campus, they would refuse to hire any future graduates from the institution. While the nominee defended the action, explaining that the situation crossed the line from a standard student protest into violent conduct, the presenter challenged whether a sitting member of the judiciary should be engaging in public boycotts. While I happen to personally agree with the sentiment against the lawlessness on that campus, doing this as a private lawyer is one thing. Doing it as a sitting federal judge is quite another. Too many Americans already feel that judges are just politicians in robes or mini legislatures. That is absolutely not what the founders intended. When a federal judge signs onto a public, political stance, it actively damages our collective effort to prove to the public that the judiciary is impartial. The nominee responded by emphasizing the inherent limitations of the bench, noting that judicial power is strictly confined to the specific cases or controversies brought before them. Unlike the executive or legislative branches, judges lack the power to write or change laws. However, the presenter maintained that protecting public perception is just as critical as respecting legal boundaries, urging the nominee to refrain from similar public declarations in the future. In a lighter but telling wrap-up to the exchange, the presenter confirmed that the nominee has completely stepped away from active posting on social media platforms like X, formerly Twitter. The nominee verified that while they use social media strictly to follow news and information, they do not post content whatsoever, a move the presenter implicitly signaled as a necessary step for maintaining judicial decorum in a hyper-connected world. This hearing cut straight to the heart of what ails the modern confirmation process and the wider legal system. If the federal judiciary is to maintain its vital legitimacy, it cannot allow itself to be dragged into partisan warfare, nor can judges give the public ammunition to view them as political actors. True judicial restraint requires more than just ruling correctly on a docket. It demands a total commitment to independence, both inside the courtroom and in the public square.